This is Bloomberg Law with June Grasso from Bloomberg Radio.
The precedent here is very simple. You have a federal law enforcement official engaging in federal law enforcement action. That's a federal issue. That guy is protected by absolute immunity. He was doing his job.
The rhetoric started on the very day that Rene Good was shot to death by an ICE officer. Vice President J.D. Vance held a news conference and declared that the ICE officer couldn't be touched for his actions. That message has been reinforced by others in the Trump administration. In fact, on Tuesday, the Department of Homeland Security posted a clip of White House Deputy Chief Stephen Miller amplifying that message.
To all ICE officers, you have federal immunity in the conduct of your duties. And anybody who lays a hand on you or tries to stop you or tries to obstruct you is committing a felony. You have immunity to perform your duties, and no one, no city official, no state official, no illegal alien, no leftist agitator or domestic insurrectionist can prevent you from fulfilling your legal obligations and duties.
So are they right? Will that ICE officer face any consequences for killing the mother of three? Joining me to answer that question is Anya Bidwell, a senior attorney at the Institute for Justice. Anya, are these Trump administration officials right? Do these ICE officers have absolute immunity?
I hate to say that they are right, but unfortunately, they are very close to being right. And there are exceedingly fewer routes to sue federal officials. It's been happening for a long time. It's not just a Trump administration invention, but what they're doing now is really exposing this gap in accountability between state and local officials. For example, Derek Chauvin, who murdered George Floyd, and federal officials like those ICE agents who killed Rene Good. So they are very close to being right. And the reason they're out there talking about this, because, before the Biden administration, the first Trump administration, the Bush administration, the Obama administration, they weren't going around and talking about absolute immunity. The reason they're talking about it here now is because they want those ICE agents to go out there and do their worst. And instead of de-escalating, instead of trying to keep the peace, they want them to be out there marching on the streets and scaring people. And so they're telling them, just so you guys know, there is nothing that can be done to you. There are, of course, some routes.
And we should mention that Rene Good's family has already hired some civil rights lawyers. So,
who said that he will file under the Federal Tort Claims Act, probably.
Okay.
Yeah.
So first of all, what about a lawsuit against the federal government, the family filing against ICE or DHS?
Yes, that is the best route, even though it is riddled with complexity, as the lawyer who is representing Rene Good's family explained. It is riddled with complexity. It is not a really full vindication of anyone's rights, but it is the best route to accountability the way the law works now. You file a claim under the Federal Tort Claims Act, not against the officer who killed you or who hurt you, but against the United States government in that officer's stead. The statute originally was really intended for things like, a USPS driver running over somebody, like a negligence type of an act. And then somebody would file a claim with the agency and the agency would compensate for that negligent action. The statute is not a great fit for constitutional violations like these. And the problem with the statute, too, is that the government invariably invokes the so-called discretionary function immunity. So they basically say the officer was acting within the scope of his duty and he was exercising discretion in that he was making a choice between whether to turn right or left. And therefore, discretionary immunity applies, and even the federal government cannot be held accountable. So those suits are very hard, but it's still the best option, the FTCA route, against the government itself.
Can you think of a big case recently or, the last case where plaintiffs won using that route?
That's a great question. There are no immediate cases that come to mind. What comes to my mind is actually the case we argued in front of the Supreme Court just last year, where there was a wrong house raid on an innocent family's home pre-dawn, even though there was an address on the mailbox right there in front of the house telling the officers that this was a wrong house to raid. And so the family sued the government for this wrong house raid. It was in Atlanta, Georgia. And the government basically argued, you can't sue us because the officer exercised judgment and there is supremacy clause immunity and discretionary function immunity. And the case went all the way to the Supreme Court. And Justice Gorsuch even said, you'd think there would be a remedy, wouldn't you, for that kind of a raid? But he said, the answer is not that simple. And the Supreme Court did not rule for the family. They remanded the case back for reconsideration. So this is pretty much like the most positive outcome is that we get to re-argue this case again years and years after this actual wrong house raid. And the family still has seen no justice. The problem then is that not too many lawyers even want to argue these cases because it takes years and years to get anywhere, as this example demonstrates.
Yeah, I remember that case. So now let's talk about the route that is difficult, impossible, and that's suing the individual officer, suing the ICE agent here.
Yes, that is impossible because they are ICE agents. And even in general, with any federal official, it's extremely difficult. So at the root of the problem is really congressional omission. After the Civil War, Congress passed a statute called Section 1983 to allow suits for the violation of the United States Constitution against state and local officials who essentially weren't complying with Reconstruction and violating people's constitutional rights. At the time, you could sue federal government in state courts, and there was no fear that state courts would be easy on federal officials. If anything, state courts at the time were hostile to federal officials. So Congress wasn't worried about federal officials not getting proper treatment in state courts. So they didn't include them in this statute. They only included state and local officials. And that omission is now used by the Supreme Court as an excuse to deny any access to courts to plaintiffs whose violations happen to be conducted by federal officials. They're saying Section 1983 does not have federal officials in there. There isn't an analog like that for federal officials. And they say Congress should amend that statute, include federal officials in there, and then we will have no problem with people opening courthouse doors. But as long as federal officials are not part of that type of a statute, we're not going to open the courthouse doors. Now, on the other hand, there is a problem that circuit courts are interpreting another statute that Congress passed as prohibiting suits against federal officials in state courts too. So that traditional remedy I told you about is also unavailable. So the way that the law stands today is that you turn to federal courts and the Supreme Court is telling you, you guys are not part of Section 1983. We can't do anything about it. And you go to state courts and they're basically saying, well, circuit courts so far have said that cases in state courts are unavailable. Though we do think that by far the best option right now is actually for states to pass their own statutes like that Section 1983 that Congress passed back in the day. And we as public interest lawyers, we have a really good argument to explain to the Supreme Court why that kind of route actually should be available. But this is something that's very new. We are encouraging states to pass these laws, and we feel very good about arguing that that's a proper route. If Congress is not going to do its job and it's not going to amend Section 1983 to include federal officials, then it's responsibility of every state to do so instead.
Not once since 1980 has the Supreme Court allowed a Bivens action, which allows people to sue federal officers directly, to go forward. Do you know why the court took that turn?
Yes, that's exactly what I was talking about in terms of Section 1983 in excluding federal officials. So in the 70s, when this case Bivens was decided, the court didn't really think that a statute by Congress authorizing a right to sue was necessary. The court at the time thought, you know what? You could just sue directly under the Constitution. Just say, my Fourth Amendment rights were violated. Here's my proof. And I demand a day in court. That was the attitude in the 70s. And then as we're going into the 80s, the court really led by Justice Scalia is championing this idea that federal courts are courts of limited jurisdiction. They should be very humble about the kind of cases that they can hear, and that without authorization from Congress, they cannot really do anything. Their hands are tied, right? And that's when they start pointing to that statute, Section 1983, and saying, federal officials are not part of that statute. We can't just imply an authorization. We must see it in a text, and we don't see it in the text. So there is nothing we can do. That really is starting to take shape in the 1980s. That's why earlier I said that it's not of Trump's administration's making, right? That really starts to take shape in the 1980s and kind of reaches into the 2000s, where we're suing FBI officials for torture. That's when the court is really starting to say, you guys, we mean what we say. We need a statutory authorization. And then it really culminates in 2022 with the decision Egbert versus Boulay, where they basically say the door is all but shut. And frankly, Justice Gorsuch, and I kind of sympathize with that, he writes a concurrence and he says, we should just overturn Bivens so we don't give any false hope to anybody. And so everybody understands that you cannot sue federal officials in state court. For as long as we have Bivens on the books, some people are under the misapprehension that there is any kind of accountability, which actually there isn't. That's why the simplest thing to do is to amend Section 1983. Then the Supreme Court will say, fine, this is great. Now you can open the courthouse door. And short of that, it's states who should take action.
Coming up next, how some states are fighting back. This is Bloomberg. On the day that 37-year-old Rene Good was shot to death by an ICE officer, Vice President J.D. Vance declared with certainty that there would be no consequences for the officer.
That guy's protected by absolute immunity. He was doing his job. The idea that Tim Walz and a bunch of radicals in Minneapolis are going to go after and make this guy's life miserable because he was doing the job that he was asked to do is preposterous. The unprecedented thing is the idea that a local official can actually prosecute a federal official with absolute immunity. I've never seen anything like that. It would get tossed out by a judge.
I've been talking to Anya Bidwell, a senior attorney at the Institute for Justice. So then, Anya, realistically, Vice President J.D. Vance and Trump aide Stephen Miller are correct in saying to the ICE officers, don't worry about what you do. You're protected.
Exactly. It pains me to say this, but they are correct. And again, like I said, previous administrations didn't like to advertise that, right? Because it's kind of appalling that you can't sue federal officials. So they didn't talk about it. Then we would go and litigate in court, and they would make those arguments in court. This administration is happy to talk about it because they want to encourage ICE to go out there and do their worst, to not care about repercussions, to not de-escalate, to basically go out there and break all the constitutional guarantees because fundamentally there isn't a way to hold them to account. Now, the federal government, if it wanted to, could prosecute those officers. But does anybody here really believe that the federal government is actually going to do that? Instead of investigating Jonathan Ross, they are investigating the wife of Rene Good, right? So we are not counting on the federal government to step in here, the one meaningful mechanism. And when it comes to state prosecutions, there's another complication and another immunity that comes in. So states, generally speaking, cannot prosecute federal officials when federal officials are exercising their federal duties. So again, the federal government doesn't even feel compelled to cooperate with the state government in this situation, doesn't even feel compelled to share the evidence because they also know that the state itself is really fundamentally unable to prosecute a federal officer. So that's where we are right now. And J.D. Vance and Stephen Miller are very comfortable going out there and telling ICE, you guys are good. There's nothing really that plaintiffs can do right now.
So Minnesota, they're going to try to do an investigation, right? I mean, is there a way, even if it's a loser way, is there a way for Minnesota to prosecute that ICE officer criminally?
I would try. Again, if I'm a state, what I'm going to try to do at this point is I'm going to work to pass a statute to allow suits for violations of federal constitution in my courts. And also, I'm going to try to prosecute the officer. Now, immediately, there will be a motion to dismiss filed. There will be arguments against it, but at least you are trying to get out there and try to do something. I would also try to just publicly even say, here's what we want to see, right? Some of it is public engagement. When you are a state, if we were to investigate, this is what we would want to see. These are the kind of things that would allow us to evaluate what took place here. Federal government, are you doing this or are you not doing this? States certainly can't just sit there and do nothing, but it's an uphill battle all the way.
What is Illinois doing? Tell us.
Illinois is not the only state, but Illinois is the one that actually passed the law. And so DOJ is suing it over it right now. So there are several states. Illinois is the first one in the line of states. Closely behind are California, New York. We also have Colorado, Oregon, and Maryland, who are looking to pass those statutes that allow people to sue for violations of the federal constitution in state courts. So Illinois was the first to get past the finish line. California just got its bill out of the Judiciary Committee this Tuesday, and many other states are working on that too. So they all kind of differ in the approaches that they're taking. Illinois took a bit more of a targeted approach with specifically talking about immigration enforcement. States like California and New York taking a more general approach and talking about just anybody who violates the United States Constitution should be held accountable. And that broader approach is actually less vulnerable to suits by the DOJ. So we are encouraging states to take that broader approach instead of singling out a particular agency or particular conduct. But we are very encouraged to see that states are starting to do this, at least some states.
And Congress has introduced an act. Where is that going?
Yes. Congress. This is the third time that Representative Hank Johnson introduced this bill. It's called the Bivens Act, referring back to that case and trying to codify that right in Section 1983 instead of just an implied right under the Fourth Amendment or other constitutional amendments. It's called the Bivens Act. Your listeners can just Google Hank Johnson, the Bivens Act, and it will come up. And you'll see how simple the amendment is. It basically says agents who act under federal law should also be held accountable, just like those who act under state law. That's it. It's the simplest amendment. It would take Congress 2 minutes to pass it if they actually had the will to do it. And again, it's not just ICE officers, right? I had somebody come to me last year where a gentleman was killed in an ATF raid. They were executing a warrant because he violated a gun show loophole. And again, it was a pre-dawn raid. The gentleman didn't know that anybody was coming. He's got a gun and he thinks somebody is about to come in and rob him and hurt his wife. So he's there with a gun and they shoot him and they kill him dead, right? And Jim Jordan was outraged by this. And I call on Jim Jordan to say, let's pass this Bivens Act so the family who was hurt by the ATF could also have a day in court, like the family here who was hurt by ICE. So it's not a partisan issue, but right now it is being treated as one, and we don't really see much movement on the Bivens Act in Congress.
Let's just say you could sue a federal officer. I mean, the federal officer would probably be indemnified, right, by the government? I mean, they wouldn't have to pay out of their own pocket anyway.
Yes, that's what invariably happens. And it happens with state and local officials as well, that they have indemnification provisions and the governments invariably indemnify them. But at least then the officer is called out, his actions are analyzed, the family gets some answers about what happened, because these days they don't even feel like they need to explain themselves. And then that officer is on notice because he did cost money to the agency, right? So there is some sort of accountability going forward too. And the agencies are much more careful about how they hire because they know that problematic officers are going to cost them a lot of money. And in some situations, when the violations are outrageous, then the government basically says, you're on your own, we're not going to cover it. It all depends. But fundamentally, the important thing is that if you allow families to sue, then they don't carry the burden of the constitutional violation, right? That they are actually able to take control of the situation and get to discovery, figure out what happened, and have the jury determine what it is that happened and who owns what. That's a very important thing to have, that simply there isn't anything even close to that right now.
And I want to mention that you've written a legal insight column for Bloomberg Law entitled Rene Good's Family Can't Sue Under Federal Law.
Just like in the op-ed, I just can't stop thinking about this, right? Where what happened to George Floyd was absolutely horrific. And at least there was some sort of a mechanism, right, for the state to look into the actions of the officer and prosecute him, and for the family to sue the municipality and say, you guys did wrong by us by hiring this guy and improperly training him. None of those options are available when it comes to federal officials. And that's something that really is not right. And you can see that kind of manifest itself in the way ICE acts, right? When Jonathan Ross shoots Rene Good and then he calls her. That's the kind of thing that I think wouldn't happen if he knew that there would be some sort of repercussions to his actions.
It's been great talking to you. Thanks so much. That's Anya Bidwell, a senior attorney at the Institute for Justice. President Trump has been insistent that the U.S. needs to acquire Greenland for national security.
If we don't go in, Russia's going to go in and China's going to go in. And there's not a thing that Denmark can do about it, but we can do everything about it.
Trump has been ratcheting up the rhetoric, but officials in Denmark have made it clear that Greenland is not for sale. Secretary of State Marco Rubio and Vice President J.D. Vance met with Danish and Greenland officials at the White House on Wednesday. Afterwards, Danish Foreign Minister Lars Løkke Rasmussen said their perspectives continue to differ from Trump's.
For us, ideas that would not respect territorial integrity of the Kingdom of Denmark and the right of self-determination of the Greenlandic people are, of course, totally unacceptable.
Joining me is Jessica Peake. She's the director of the International and Comparative Law Program at UCLA Law School. Jess, so after that meeting, it doesn't seem like diplomatic negotiations are going so well.
Yeah, I mean, as you said, the foreign minister has said there's a fundamental disagreement and that Trump's threats, repeated threats to take over Greenland were totally unacceptable. I think they also said that the conversation was frank but constructive. And so then the question is, what does that actually practically mean? I know that there has been an agreement to create a high-level working group to discuss the ways to try and determine a path forward from here. But at the same time, we have President Trump still maintaining that his intention is to take over Greenland. And so for as long as he maintains that position, it's very difficult to see what the path through is, because Denmark, very understandably, has been, full-throated in their condemnation of Trump's attacks as threats to international law and the sovereignty of Denmark and the self-determination of the people of Greenland. So those two positions are just fundamentally opposed to one another.
So just explain the international law here.
Yeah, so any threat or use of force against Greenland, such that we have right now, is a violation of Article 2.4 of the UN Charter. So threats alone are enough to be a violation there. It's worth noting that there are a couple of lawful bases for a use of force. Neither of them are present here. One would be a Security Council resolution authorizing force, and the second would be an action of self-defense in response to an armed attack under Article 51 of the UN Charter. And we don't have either of those here. So already, even these threats are enough to constitute a violation of Article 2.4 of the UN Charter. And even without any direct use of force, the US is also violating the customary international law prohibition on intervention. And this is a prohibition that prevents states from intervening in the domain reserve of another state. And so the domain reserve is areas of state activity that are really the internal or domestic affairs of a state, and therefore within its domestic jurisdiction. This customary prohibition has been recognized by the International Court of Justice in numerous occasions, including in the military and paramilitary activities in and against Nicaragua case in 1986 that involved the United States, and also the armed activities on the territory of the Congo case in 2002. Trump's language around his threats towards Greenland, things like they can take the easy way or the hard way, can be interpreted as a form of coercion and therefore a violation on this prohibition of intervention.
If the U.S. military was used, would that be comparable to the situation with Russia and Ukraine?
Yes, it would be a violation of Article 2.4 of the UN Charter and an act of aggression, similar to what we just saw a week and a half ago with the Trump invasion of Venezuela, which was also a violation of Article 2.4 of the UN Charter and an act of aggression.
If he strikes in Iran, will that also be a similar violation?
Yes. The only use of force that is permissible is either in response to an armed attack as an exercise of Article 51 of the UN Charter, which we don't have an armed attack against the United States from Iran, or under a Security Council authorization, which we also do not currently have in relation to Iran. So yes, we would be talking about potentially very similar violations of international law.
I mean, the reason that Trump keeps giving for going into Greenland is that it's needed for the national security of the United States. But Greenland also has, amazing raw materials. And as far as security, has Greenland ever refused to allow the U.S. to establish more security there, bases or whatever?
So, experts seem to agree on the strategic importance of Greenland for the United States national security. But there's no reason that requires the United States to control or own Greenland. And in fact, trying to control or own Greenland really seems counterproductive to US national security, as it's going to damage this vital relationship between Greenland and Denmark and other NATO members and the United States. And, as you alluded to, the Greenland and Denmark have been very cooperative and permissive of the US maintaining or having access to the territory of Greenland for national security measures and for military presences. If we think as far back as 1940, the US military forces occupied Greenland when Denmark was invaded by Germany, and vital Air Force installations were stationed there for US troops to get to Europe. Similarly, there was very strong cooperation during the Cold War between the US and Denmark to defend Greenland from threats against the Soviet Union. And so it's very unclear to me why we're treating this situation, where presumably the national security threat is one coming from Russia. We have a model of cooperation there that existed previously. And I don't think Denmark or Greenland have indicated that they're not willing to maintain that level of cooperation. But these repeated threats against Greenland by the Trump administration are undoubtedly going to damage the relationship between these two countries and Denmark.
The Danish Defense Ministry announced that it's increasing its military presence in Greenland, along with some NATO allies. France, Germany, Norway, and Sweden announced that they were sending very small numbers of troops. So this seems to be more symbolic than anything else.
Yeah, I think at the moment this is just a show of political support, right? It's NATO allies going to indicate their support to Denmark in this situation. It also might be, and I have no insider knowledge, but it might be also to scope out how a ground deployment could be carried out if one were required further down the line, if Trump actually conducted military force in Greenland. And this really brings us to, how this might play out with NATO, right? So NATO is a military and political alliance that was formed by America and European countries in 1949 to provide collective security and to defend its members from threats. And Article 5 of the NATO treaty contains a collective defense provision. And so that basically states that an attack on one NATO ally is attack on all NATO allies. And in response to any attack, each of the NATO allies, in the exercise of the right to individual or collective self-defense recognized by Article 51 of the UN Charter, will assist the party that is attacked. This is a legal obligation. There are some things to consider around this, right? So one is, does Greenland fall under the auspices of NATO? And undoubtedly it does. Article 6 of the NATO treaty basically provides that an armed attack must be committed against the territory of any parties in Europe or North America. Geographically, Greenland is part of North America as it sits on a North American tectonic plate. But geopolitically, it is tied to Europe and it's a politically autonomous territory within Denmark. And so it's very clear under international law that Denmark has sovereignty over Greenland and Greenland is part of Denmark. This was confirmed by a case of the Permanent Court of International Justice back in 1933. Greenland has been incorporated in Denmark through domestic legislation in the 50s that was recognized by the UN General Assembly. And really, over the past 75 years, the United States has repeatedly acknowledged that Denmark has sovereignty over Greenland. And so there's really no question that Greenland falls within the auspices of the NATO treaty. So the question is, what happens next? Article 5 of NATO requires that there be an attack against a NATO territory, and we don't have that attack yet. So if an armed attack were to occur, Article 5 could be triggered at the request of Denmark. And if Denmark made that request, then all of the NATO allies would be obligated under a legal obligation to respond. They do not need to respond with the use of force, though. So there are other things that they could do. So the only other situation in which Article 5 has been invoked was after 9/11. And the collective security responses under Article 5 there really range from intelligence sharing to military action. And so there's a whole host of things that could happen that would be, not a full military action within the territory of Greenland. Denmark could also request assistance from other NATO allies under Article 4. That would allow NATO allies to consult where there's been a threat to the territorial integrity or political independence or security of any of the states, and that's what we have here. That would not allow the NATO allies to exercise any force, though. And so I think what we're seeing with these, military troops from NATO allied countries going to Greenland and from Denmark as well is really just a show of political support at this point. There has not been any official requests that I'm aware of made by Denmark under either Article 4 or Article 5, but the NATO agreement is there and is to be activated for these very kinds of reasons, right? Like that was the whole rationale behind the creation of NATO. And so the potential for it to be activated definitely exists.
So I guess it's just wait and see right now. See how serious Trump is about acquiring Greenland.
Yeah, we do have to wait and see. I mean, I think we're seeing some pretty strong rebukes from Congress on this, right? So on Monday, there was a bipartisan bill introduced, the NATO Unity Protection Act, that would prohibit the use of U.S. Department of Defense or U.S. Department of State funds to blockade, occupy, annex, or assert control over the sovereign territory of a NATO member state without that ally's consent. So that's, potentially something there. I think overall, the introduction of that bill is very welcome development. If it receives very robust bipartisan support, it would signal to our NATO allies that Congress intends for the US to abide by its commitments under the NATO treaty. If such a bill were to pass, it would place restraints on the president, or it should place restraints on the president acting unilaterally and continuing to threaten our NATO relationship. However, we have seen that President Trump has made repeated threats against NATO in this term and the last, and we've seen in other instances that the president is willing to flout congressional authority when it suits his broader agenda. I also saw reporting this morning that there is a bipartisan resolution being introduced today, again repudiating President Trump's threats against Greenland and affirming the US respect for the sovereignty of Denmark and of Greenland. And it also warns that any US military action against Danish territory would require Congress's approval. So again, that should put limits on the ability of the president to act unilaterally. Whether or not it does, I think, is an open question at the moment.
We'll see if Congress actually moves forward on any of those. Thanks so much, Jess. That's Jessica Peake, director of the International and Comparative Law program at UCLA Law School. Let's turn now to the FBI searching the home of a Washington Post reporter who allegedly obtained and reported on classified information from a Pentagon contractor who's currently in jail. That's according to Attorney General Pam Bondi. The Washington Post identified the reporter as Hannah Natanson. She was at her home in Virginia at the time of the search and was told she was not a target of the probe. Joining me is First Amendment attorney Jeff Lewis of Jeff Lewis Law. Jeff, how unusual is it to execute a search warrant at a reporter's home?
It's very unusual. I'm surprised a judge signed off on such a warrant, given the facts of this case, that apparently the leaker has been detained or arrested already. So it's not like there's this hot threat, a time-sensitive threat going on, that rather they have the leaker. They know who he is. So I'm surprised.
According to reports, the government said that she was engaged in a conversation with the leaker involving classified information. Does that make any difference?
Well, the standards the court uses is there an immediate harm to national security? Is the reporter in possession of documents that would violate, like, the Espionage Act? Those are the kinds of the questions that the court looks at. Not, is a reporter speaking to a confidential source, but is there immediacy? Is there an immediate threat and a grave threat to national security?
There is no law that makes it a crime for a journalist to obtain or publish classified information, but are there any repercussions from the Assange case?
I don't think that the president was criticized as heavily then as the president's being criticized now in terms of the Trump administration, their use of warrants. Because in the Assange case, there's always this assumption, there was always these norms that these materials would be safeguarded, that they'd be only used for purposes of the Assange prosecution and not used for political or purposes to deter reporting. In this case, in this day and age, with concerns about the Trump government's violation of freedom of the press and freedom of speech, people are concerned about the deterrent effect here, and that this seizure was more than just investigating this leaker, but instead was meant to send a signal to anyone who's critical of the Trump administration or communicates with leakers.
Now, the Justice Department has their own regulations about this, and they've been changed under this AG Pam Bondi. Can you explain what the regulations were before and what they are now?
Well, yeah, normally it's the process, especially when you have a search warrant as opposed to an exigent search, that materials seized like this are escrowed, if you will, or embargoed, and they're placed in a secure setting, and they can only be used, the seized materials can only be accessed for a very specific purpose related to the criminal proceeding that the search warrant was issued in. After Bondi took over, I believe those regulations were relaxed such that there's fewer safeguards on what that information can be used for, what the seized devices can be searched for, and there's no escrowing or embargoing of these materials.
What can the reporter do at this point to get her materials back?
Yeah, after the fact, it's hard because the government could have made copies of the image devices, right? The phones and the watch and the laptop. So it's hard for this reporter to have a remedy. She can certainly get her gadgets back, but the invasion, the theft of her information, you'll never undo that. This underscores the needs for reporters to use end-to-end encryption, to turn off face recognition on their phones, to make it as hard as possible for gadgets to be accessed by the government if they're physically seized.
This might be about more than just the classified information. In her reporting, she noted that she had amassed like more than 1,000 sources of federal workers who were frequently communicating with her. And one wonders if, they're looking for more than just classified information related to this one government worker.
Absolutely. Both looking for additional leakers within the government and a deterrent to leakers and a deterrent to reporters for communicating with leakers. There are bigger implications than just one government contractor here.
Is there any way to, impede the government's coming after reporters?
Well, Congress could pass further legislation to restrict the power of judges to issue search warrants. That's one option. Reporters and newsrooms can protect themselves by having policies regarding security for their electronic gadgets and using only end-to-end encryption, software like Signal to communicate with confidential sources, and to only use specific devices when sensitive confidential source information is gathered by news reporters.
Thanks, Jeff. That's First Amendment attorney Jeff Lewis. And that's it for this edition of the Bloomberg Law Show. Remember, you can always get the latest legal news on our Bloomberg Law podcast. You can find them on Apple Podcasts, Spotify, and at www.bloomberg.com/podcast/law. And remember to tune into the Bloomberg Law Show every weeknight at 10 p.m. Wall Street time. I'm June Grasso, and you're listening to Bloomberg.